Senator Hirono was first.
I thank my colleague. Count me in too. Mr. Chairman, I too referred to a so-called committee confidential document deemed such by one Bill Burke. And we all know who he is at this point. And had the nominee asked me for a copy of that so-called committee confidential document, I would have been happy to release it to him or give it to him. I am releasing that document to the press, and I would defy anyone reading this document to be able to conclude that this should be deemed confidential in any way, shape, or form. Thank you. The chairman asked, and you responded that you had not engaged in any secret handshakes, winks, and no discussions relating to the Mueller investigation. On the other hand, your Minnesota Law Review article, wherein you said Congress should protect a sitting president from criminal or civil proceedings, is a pretty big signal or notice to this president, and as far as I can see, it is a very big blinking red light. I was also listening to the series of questions asked of you by Senator Blumenthal regarding the comments made by the president referencing judges. Is disagreeing with the president a concern to you?
I'm an independent judge. I have ruled in cases such as the Hamdan case, where that was a signature prosecution of the Bush.
So you're saying that disagreeing with the president is not a concern to you. Is that what your response is?
I am saying that as a judge deciding cases or controversies, I decide cases based on who has the better position. I've done that for 12 years, and I have a record to show that, in 307 opinions and over 2,000 cases.
Is disagreeing with the president a concern to you when it's not a case in front of you?
Following the lead of the judicial canons, following the lead of Chief Justice Roberts, who leads the federal judiciary, we stay out of politics. We don't comment on politics. We don't comment on comments made by politicians. We stay out, way away from politics.
So to the extent that a comment is made by the president, then disagreeing with him, any statement that the president makes is political to you, and you will not respond. Thank you. Let me follow up with some questions that some of us had of you yesterday and last night. Yesterday evening, Senator Tillis asked you about Rice v. Cayetano, and that's the case that I discussed, where the issue was whether the state of Hawaii could restrict those voting for officers of the Office of Hawaiian Affairs, which administers certain lands held in trust for Native Hawaiians to only Native Hawaiians. In fact, Hawaii felt so strongly about the importance of its trust obligations to the Native Hawaiian community. The people of Hawaii voted to create the Office of Hawaiian Affairs, also known as OHA, in our Constitution. It's not just a law, it is in our Constitution that we created the Office of Hawaiian Affairs in 1978. In answering Senator Tillis, you described the case, Rice v. Cayetano, giving it a different and grossly misleading spin. What you said totally ignored and disparaged the trust obligation that the state had to Native Hawaiians, and this trust obligation led the state to create the Office of Foreign Affairs and to decide who should be able to vote for the leaders of that office, Native Hawaiians. You said the state, quote, denied voting to people who were residents and citizens of Hawaii but were not of the correct race, and therefore African Americans and Latinos and Asian Americans and whites were barred from voting for that office. You then misstated the holding of Rice v. Cayetano. You said, quote, the Supreme Court held that that was a straightforward violation of the 14th and 15th Amendments of the U.S. Constitution. I'll get to your misstatement later, but my first question to you is, do you think that Rice can be used to justify the argument that programs to benefit Native Hawaiians are subject to strict scrutiny and of questionable validity under the Constitution, as you noted in the email that I referred to last night?
Right. Appreciate the question, Senator, and thank you for raising it. In Rice versus Cayetano, Justice Kennedy wrote the opinion for 7-2 to Supreme Court, saying that the voting restriction in that case violated the Constitution. To your question about, I'm getting to your question, about the other question, That was something I wrote in an email then, and if that issue came before me, there's been subsequent precedent that would be relevant, and I would have an open mind about how to apply the precedents of the Supreme Court, the strict scrutiny or intermediate scrutiny that would apply in a case like that, and would consider the facts and circumstances.
Rice was the 15th Amendment case. It was a state action case. So should another state action voting case come to you, or you would apply Rice. But my question was whether you would turn to Rice for the proposition that programs that benefit Native Hawaiians should be subject to strict scrutiny because they are of questionable validity under the Constitution.
Right.
That is my question.
Yeah, so I appreciate that, Senator, and I think that would be analyzed in the light of Rice, but in the light of all the other precedents of the Supreme Court on programs that, so contracting programs and higher education programs, which has set forth a body of precedent under which programs like that would be analyzed. And I would look at the specific program under the facts and arguments of that case.
So considering that Rice was a 15th Amendment case, and you're citing to other examples where other constitutional provisions may come into play, Rice should be limited to a 15th Amendment case, because that is what the court decided. But in fact, you answered last night that the case was decided under the 14th and 15th. You said it was a straightforward violation of 14th and 15th Amendments of the U.S. Constitution. Right. So that is not what the court did, as I've iterated, and I think you agree, because, I mean, that's what you wanted the decision to be based on. You wanted the Rice decision to be based on the 14th and 15th Amendments. So that is not what they did. So this reminds me of the criticism that was lodged against you in the U.S. v. Anthem case, where the majority said that you applied the law as you wanted it to be, not what it is. The question to you is, where in the Rice Court's opinion did the court decide the case on 14th Amendment grounds?
Well, the principle of the 15th Amendment is that there can't be voting restrictions on the basis.
I'm asking you, where in the decision does the court rely on the 14th Amendment? You're citing to the 15th Amendment.
Well, I think the 14th and 15th Amendments, I think both prohibit restrictions on voting on the basis of race. The 15th Amendment explicitly, this refers to voting, but the 14th Amendment, of course, applies, as I read the precedent, to all state restrictions on the basis of race.
Well, the 14th Amendment mainly relies on one man, one vote. That's a whole other line of cases, but that is not what the court chose to decide, base its decision on Rice. So I would expect someone who's going to be on the Supreme Court to be very, very careful in citing precedent and to be very accurate in saying what the court based its decision on. And it is totally clear to me, because you have not been able to cite to the opinion in Rice that says we are deciding this case based on the 14th Amendment. They did not. Mm-hmm. So that is very disturbing to me, that you would cite that case for the proposition that it was based on the 14th Amendment when clearly it was not. And you have been, as I noted, been criticized for citing law as you wished it to be and not as it is. Let me go on to Priest for Life case. The Free Exercise Clause of the First Amendment ensures that each person has a freedom of conscience to pursue their own religious values. These rights end where they would interfere with another's ability to do the same. However, in recent years, a wide range of individuals and institutions have received special dispensation to impose their beliefs in others, and of course, most notably, this is the Hobby Lobby versus Burwell case. So a case that raised those kinds of issues came before you in the Priest for Life. And in that case, one of the things you had to determine was whether there was a substantial burden on the employers. And their employers, their claim, the act of filling out a form to let their insurance company and Health and Human Services know that they had a religious objection, weren't going to cover the contraception, was overly burdensome. And it wasn't the priests who were providing the contraception coverage, a third party was. And the priests weren't forcing that third party to cover birth control. Congress was through the ACA. In your dissent, you thought that was too much. You said the employer's religious exercise was substantially burdensome and that they could deny contraceptive coverage to their employees. So my question to you is, do you believe that the freedom of religion clause supersedes other rights?
No, Senator, I made clear in that decision that the Religious Freedom Restoration Act has a three-part test. First, substantial burden. I found that satisfied there based on the Hobby Lobby precedent, which I was bound to follow in the Wheaton College. Second, compelling interest. I did find a compelling interest there for the government in ensuring access. And then the third prong is least restrictive means, and I made clear there, I cited Reva Siegel's law review article, made clear the...
Let me get to the first prong, which is whether this was unduly burdensome. So you determined that filling out a two-page form was unduly burdensome. Did you know?
I concluded that penalizing someone thousands and thousands of dollars for failing to fill out a form when they didn't fill it out because of their religious beliefs was...
No, if they filled out a two-page form, they could have been totally insulated from thousands and thousands of fines. So the question became not the fines, that was irrelevant. The question was whether a two-page form was overly burdensome, and you determined it was overly burdensome. So, it kind of defies logic to me. Let me go on to what I would consider to be a related case, which is Garza v. Hargan. And I would consider these two cases as being related because, first of all, they are both cases about women's reproductive freedom. And second, while you balance the interests of the parties involved in very different ways, you come to different conclusions. What's similar is, in both cases, you ruled against the women. In Garza v. Hargan, been brought up before, you argued that the government's basically charade of trying to keep a young woman in custody until it was too late to get an abortion was not an undue burden on her rights. So forcing her to remain in HHH's custody and, in fact, considering this to be a parental consent case, which was not the case, it's irrelevant. And in Priest for Life, you insisted that a government requirement that religious employers filled out a very short form declaring their objection to providing health care was too much of a burden. And in each case, you reached your desired outcome, which is against women's reproductive rights. And you ignored the common sense meaning of burden. By the way, filling out the two-page form, the majority opinion did not consider that overly burdensome. And I really think that your conclusions that filling out this form is overly burdensome defy logic. But it is logical in the sense that in both cases you were against women's reproductive rights. So how is it possible for me to draw any other conclusions that basically you really want to limit a woman's reproductive rights? So even though you engage in a balancing test, in the case of Priests for Life, filling out a two-page form was too much. But in the case of Garza, it was not too much to have this young woman remain in custody and to be forced, as far as you're concerned, to wait around for foster parents to be found.
In each case, Senator, I was doing my best to apply the precedent on point. The Hobby Lobby and Wheaton College case, the Wheaton College case had dealt with a form, and so I followed as best I could the Wheaton College case. The Supreme Court had, I think, a 6-3 vote, found or granted an emergency injunction in that case. I tried my best to follow that precedent.
See, that's the thing about following precedent, because, oftentimes your own perspective, a judge's ideological viewpoints, et cetera, come into play as to which precedent to apply, how to apply the precedent, and what parts of the precedent you want to apply. Let me get to something that should be really simple. I think you said yesterday that Korematsu had been overruled. And in Trump v. Hawaii, the Chief Justice wrote, Korematsu was gravely wrong. The day was decided has been overruled in the court of history, and to be clear, has no place in the law under the Constitution. I'm just really curious. Is being overruled by the court of history a valid way to overrule a case?
I think what the Chief Justice was recognizing in that case was the same thing the Supreme Court, Justice Brennan, had recognized in New York Times versus Sullivan, where he said the Sedition Act of 1798 had been overruled in the court of history. In other words, there wasn't a specific case that arose, but it was important for the Supreme Court to nonetheless recognize that this law, in the case of the Sedition Act, and this precedent in the case of Korematsu, was no longer good law, and to note that, and so the Chief Justice noted that in the Trump versus Hawaii.
This was, by the way, long after Korematsu's case was brought, many, many years later, when it was made very clear that Korematsu had been wrongly decided. It would be nice if the court of history can overrule cases, but let me go on to Trump v. Hawaii. The Chief Justice declared that Korematsu has nothing to do with this case, but Justice Sotomayor called the, I'm quoting her, holding all the more troubling, given the stark parallels between the reasoning of this case and that of Korematsu v. United States. And she continued, quote, in Korematsu, the court gave a pass to an odious, gravely injurious racial classification authored by an executive order. And basically the court invoked an ill-defined national security threat to justify an exclusionary policy and sweeping proportion. Now, aren't the parallels between the cases very strong? Because in Trump v. Hawaii, as it was in Korematsu, the president discriminated against a minority group on national security grounds, and in both cases, the court didn't question an obviously bogus justification. They did not, in both cases, go behind the bald-faced assertion by the president that this was based on national security. So where does this reasoning take us? Because if the president can claim national security as a shield against any challenge to his actions, under what circumstances do you think a court, based on the most recent case, Trump v. Hawaii, should a court look behind the president's stated justification of national security?
The Supreme Court's made clear, Senator, in a variety of cases that it will hold the executive branch to account in national security cases. The Boumediene case in 2008, the Youngstown case in 1952, the Hamdan case. So the national security is not a blank check for the president. The Supreme Court has said, Justice O'Connor writing in the Hamdi case. And that's an important principle under our Constitution, is that even in the context of wartime, the courts are not silent. Civil liberties are not silent. In the particular case you're raising, Chief Justice Roberts concluded that there was no violation in that case, but the general principle that I think is important to reiterate is that we're a nation of laws, including in the national security context, and that the precedent of the Supreme Court over the course of our history has recognized that the law applies even in wartime and national security.
Well, the thing is, though, the most recent iteration of an articulation of national security to justify an executive order is Trump versus Hawaii. The record was replete with references and statements that the president had made as to what his true intentions were, that this was a Muslim ban. He talked about it during the campaign. He talked about it after the campaign. He told the Justice Department, he told the Justice Department as president, get me a iteration of this ban that would withstand constitutional challenge. And so the most recent iteration is very concerning, because it says to me that the president can say, this is based on national security, and the Supreme Court made very plain that it would not look behind that articulation. Let me move on. Running out of time. So the Warren Court. In 2017, you gave a tribute to the late Chief Justice William Rehnquist. You explained that you chose the topic because it pains me, that many young lawyers and law students, even Federalist Society types, have little or no sense of the jurisprudence and importance of William Rehnquist to modern constitutional law. And then you went on, they do not know about his role in turning the Supreme Court away from its 1960s Warren Court approach, where the court in some cases has seemed to be simply enshrining its policy views into the Constitution, or so the critics charged. And then you praised Chief Justice Rehnquist because he righted the ship of constitutional jurisdiction. What decisions of the Warren Court were you referring to as simply enshrining its policy views into the Constitution? Were you thinking about Brown? Were you thinking about Loving? Were you thinking about any of the Warren Court decisions that created rights for individuals, privacy rights? There's a whole array. So which were the Warren Court decisions that you thought needed to be righted by the Rehnquist Court?
And I said, or so the critics charged. I identified the areas where Chief Justice Rehnquist had helped the court, I think, reach consensus or maybe a middle ground on areas such as criminal procedure, that is religion clause cases, and I identified all those in the speeches. When he passed away, and even before he passed away, many of the justices who worked with him were very much praiseworthy of Chief Justice Rehnquist for fiercely defending the independence of the judiciary.
I'd really be interested to know the particular cases that you were referring to, not general kinds of cases, particular cases.
I think I referred to them in the speech, but thank you, Senator.
After Senator Kennedy asks his question, we'll take a 30-minute dinner break.